Welcome to Tax, Retirement, Investment, and Insurance Planning Strategies and Solutions. I'm Peter Wouters. Aging individuals are faced with increasingly complexity involved in coordinating an increasing number of potential income sources, which may come in at different times, are taxed differently, have different levels of guarantees, have varying degrees of flexibility, and involve different levels of involvement by people. People are subjected to acronyms and jargon that can add to the confusion, make them feel ignorant or ill-informed, and frankly turn them off. So having just said that, I'm going to break all my own rules because you know that I'm a great proponent of not using acronyms. But in this presentation, which is so jam-packed of data and information across the country, I asked for some license to be able to use some acronyms just so we can get through this material, but only for educational purposes. Again, I strongly encourage you not to use these acronyms when you're having your conversations and meetings with advisors and other professionals. Now, to make things even more complicated for people, not necessarily for this presentation, some of the underlying products and programs may have similar characteristics and objectives, which make it difficult for advisors to know what the opportunities are and what the limits are corresponding to each product and program. And this is a problem, particularly in the context of people's pensions, considering that for many clients, the pension or commuted pension benefit they will receive from their employer might well represent a significant portion of their retirement. So what are we going to cover off today? Well, as an overview, this session will go over the rules around pension amounts that have been moved from an employer's pension plan to a registered individual retirement account. You as attendees will learn about differences in treatment across the country in terms of accessing values. We'll also learn about particular strengths when managing locked-in retirement accounts. And hopefully this will give you important information that you can use in financial and retirement planning with your clients, particularly when cash may be needed because of the COVID-19 pandemic. As always, I have to share with you the most important slide of the presentation according to legal and compliance, and that's this disclaimer side. And as you know, of course, I'm not here to give you formal legal tax advice, and I need to give you a further disclaimer from FP Canada because we have applied for credits from that association as well, as this does meet the minimum requirements for CE approval as outlined under their program of continuing educational guidelines. So let's move on. Today's session will cover the following main areas. 1, the origins of locked-in retirement accounts, which is an important consideration for advisors working with clients who have been presented with the opportunity to commute their company pension plan and transfer the eligible amount to a locked-in account. 2, the distinctions between withdrawals and taxable withdrawals. 3, special withdrawals from locked-in plans, especially important considering the impact the pandemic has had on people's finances. There may be increased inquiries and demand to access locked-in funds in order to cover living expenses and special needs. 4, you'll cover a planning opportunity to unlock some locked-in funds while leaving the unlocked monies registered and now more easily accessible. And 5, the session will also point out the mismatch of certain products, accounts, and retirement planning structures. So let's begin with the origins of locked-in retirement accounts. Registered pension plans can fall under either federal or provincial jurisdiction legislation. Federal legislation applies to pension plans of federally regulated private companies like banking, airlines, or telecommunication industries. Federal legislation also applies to pension plans of public and parapublic federal organizations. Among others, it would apply to people working for the Canadian government, the Army, or the Canada Revenue Agency. Provincial legislation applies to pension plans of provincially regulated private companies. And it also applies to pension plans of public and parapublic provincial organizations like universities, public health institutions, and employees of provincial governments. The effect of the COVID-19 pandemic has done a number of things within this organization. As you can see, we have these different types of pension plans available federally, provincially, but we had a number of things that have actually come up. The effect of the COVID-19 pandemic on the financial and economic environment has resulted in market volatility And this has made the impact on the solvency ratios of financial institutions difficult to gauge. And the superintendent of financial institutions came to view that transfers or annuity purchases from defined benefit pension plans could impair the solvency of these organizations, particularly their pension plans. So as a result, the superintendent determined that it would be prudent, as a temporary measure anyway, to prohibit the transfer of assets from defined benefit plans through portability plan transfers and buyout annuity purchases. As such, the following things happened. On March 27, 2020, consent of the superintendent has been required for any transfers or annuity purchases rather than being granted the usual automatic consent if certain conditions are met. Some adjustments were announced on May 7th to provide some easing of the portability freeze that had been in place since March 27th, while maintaining some prudent restrictions on portability transfers and annuity purchases from defined benefit pension plans. And then in August, in fact, the August 31st, the portability freeze was lifted, and the directives of the superintendent of financial institutions has been revised to once again allow for portability transfers subject to conditions similar to those that applied prior to March 27, 2020. So we have all of these effects that occurred back in March, as I actually showed you. But before I go into that, let me go back and actually look at the origins again of those locked-in retirement accounts. A locked-in RRSP or a locked-in or a LIRA, as you'll come to know it, is created when the value of contributions, which is the employer contributions plus the employee contributions plus interest and earnings, are transferred from a registered pension plan to an RRSP. A locked-in RRSP and a LIRA have very similar attributes, and the two terms are often used interchangeably, even though they're not exactly the same. Federal plans continue to use the term locked-in RRSP, and the provinces use the term LIRA to designate the account to which pension plan assets are transferred. Now, the province of Prince Edward Island hasn't adopted any legislation to deal with locked-in accounts, and as a result, locked-in plans don't exist in Prince Edward Island, and Prince Edward Island residences should refer to their specific pension plan documentation for further guidance. So a person who owns a LIRA owns an investment, which has the fiscal status of an unmatured RRSP wrapped in the contractual requirements of a LIRA that we'll go through in a couple of minutes. And it's that same principle with a LIF, which means that a person who owns a locked-in fund owns an investment which has the fiscal status of a RIF wrapped in the contractual requirements of a LIF. Are you confused yet? That's why I ask you not to use acronyms. Now, applicable pension legislation components continue to apply to monies transferred from a pension plan to a locked-in RRSP or a LIRA. And transferring the value of the pension, also referred to as commuted value, to a locked-in vehicle, such as a life income fund or a locked-in registered retirement savings plan, to another pension plan, or using the value of the pension to purchase an annuity, is called exercising portability. So the possibility to exercise portability has been limited by the superintendent of financial institutions in the aftermath of the COVID-19 pandemic. And that's really what I covered off in this slide earlier when I made all those comments about those restrictions. So if you've had some pushback and you say, what am I going to do? I got to give up on that. And your clients are saying, geez, have the rules changed right now? They're really asking you to help them with those rules and to help them with being able to not circumvent, but take advantage of any opportunities that exist to get some easing and get some access. Now, LIRAs and LIFs are both locked-in funds. The L in front means it's locked-in funds. And there are restrictions on access to monies in these accounts. RRSPs and RIFs are non-locked-in funds with no restriction on access to funds. The relationship between a LIRA and a LIF and an RRSP and a RIF are similar. Both the LIRA and the RRSP are vehicles that are conceived for the accumulation phase of assets. And when you hear the term LIF and RIF, well, that refers to vehicles that are conceived for the disbursement phase of assets or the spending phase of people's lives when they have these monies. An important difference between a LIF and a RIF is the different limits of withdrawal amounts. A minimum amount must be withdrawn from a RIF according to the Income Tax Act. However, there's no maximum amount that must be withdrawn. As a general rule, all payments are taxable in full as regular income when received. For a LIF, a minimum amount must also be withdrawn, but this minimum amount is the same as for a RIF. But there's a maximum amount that's established in the contract under which the LIF is established. We'll come back to that later. So a LIF has both a minimum and a maximum, where a RIF has a minimum but no maximum when it comes to withdrawals. So again, we're looking at the origins of withdrawals, and really, before going into the different possibilities of withdrawals, it's important to understand that not all withdrawals are taxable, and they cannot all be done on a tax-deferred basis. So some are and some aren't. Think about withdrawals out of the home buyer's plan with its stipulations on repayment. And this is due to the fact that possibilities and obligations to withdraw monies from a certain plan can have different origins. They can come from tax legislation, they can come from legislation on pension plans, and in fact, they could come from contractual clauses which have to be included in the contract according to the applicable legislation on pension plans, especially in the cases of LIRAs and LIFs. For instance, if a clause of a LIF allows a plan holder to withdraw 100% of the amounts held in that LIF contract, the withdrawal could be done by withdrawing the amount in cash, which of course would be taxable. Two, by transferring directly the amount to another RIF, which would be a tax-deferred transfer since, as we saw earlier, a LIF is a RIF for tax purposes. And such a transfer may end the characteristics of a retirement plan in the sense that it wouldn't be locked in anymore. Now, what happens at maturity? Well, generally speaking, the only way to get money out of a locked-in retirement account or locked-in RSP is to retire. The question is then to determine, what does a plan consider retirement age? Well, the jurisdiction of a client's plan, and in certain provinces, the provisions of the client's registered pension plan will affect the age limitations regarding the maturity of that plan. The maturity options also depend on the governing jurisdiction of the plan and include a combination of a life income fund or a LIF, a life annuity, a locked-in retirement income fund or an LRIF, a prescribed or restricted life income fund or an RLIF. All jurisdictions except Saskatchewan allow a life income fund as a maturity option, and all jurisdictions allow a life annuity as an option. Now, Newfoundland and Labrador is the only jurisdiction in which a locked-in retirement income fund or an LRIF is allowed as a maturity option. Prescribed RIFs are allowed as a maturity options in plans under Saskatchewan and Manitoba jurisdictions. And finally, plans governed by federal jurisdictions are the only one where a restricted life income fund, or called an RLIF, is allowed as a maturity option. And again, that's why I don't like using all these acronyms and initialisms. They add to the confusion of what is already a pretty complicated subject. Now, there have been some changes to Ontario defined contribution pension plans. Prior to January 1st, 2020, members of an Ontario regulated defined contribution pension plan were required to transfer their money to a life income fund, a LIF, at a financial institution before they could start receiving their retirement income. But effective January 1st of 2020, Ontario's Pension Benefits Act allows, but does not require, pension plan administrators to pay income directly from the plan instead of through a LIF by establishing what is called a variable benefit account, or a VBA. Now, variable benefits are now allowed in all provinces except New Brunswick and Newfoundland and Labrador. Plan sponsors are not required to offer variable benefits, but those who choose to do so will offer a more attractive plan by providing access to competitive investment management fees to their former employees during retirement, and more developed investment options and better governance. So again, this is not a must-have, but it's an option that they actually have. And it's a way for companies to actually keep those monies within the organization. So you have another competitor on board here, but again, this has been available in most of the provinces already. So let's look at special withdrawals here. In certain specific circumstances, it may be possible to withdraw amounts from a locked-in plan before the maturity of the plan. The details of the circumstances vary a lot depending on whether the locked-in plan is subject to federal or provincial jurisdiction, and if it's a provincial plan, under which provincial jurisdiction it falls. Furthermore, with provincially regulated plans, the applicable legislation is not based on applicable legislation where the employer is registered or where the employer's head office is situated, nor where the plan was set up, and certainly not the province or territory where the participant lives. Those aren't the determinants of what defines the legislation and what you can do with one of these locked-in plans. So who does govern locked-in retirement accounts? Well, for employers under provincial jurisdiction, the regulations of the province where the member worked when they ceased active membership in the pension plan govern. For employers under federal jurisdiction, well, they're subject to federal regulations regardless of where the member worked when they ceased active membership in the actual plan. Let's consider 5 scenarios. I know that I do a lot of case studies, and I find that case studies sometimes make the understanding of all this a lot easier. As mentioned, it's important to remember that the rules applying to a LIRA depends on whether the pension plan is subject to provincial or federal legislation. So we need to have an analysis of all the facts, and that needs to be done on a case-by-case basis. In the first scenario, a client lived in Toronto, where he worked for the government of Ontario and had a registered pension plan as part of his compensation. The client stopped working for the government of Ontario when he moved to Montreal and transferred the registered pension plan to a LIRA when he was in Montreal. He used an advisor referred to him in Montreal to set up the LIRA. Legislation of what jurisdiction will apply to that LIRA? Well, it's the legislation of Ontario. The rules of the province of Ontario apply because that is where the plan member worked when he ceased employment for this provincially regulated employer. Therefore, the special withdrawal limits imposed by that province shall be considered if that client now wants to make a withdrawal. Okay, so the rule is Ontario. Now consider the same client who lived in Toronto and worked for a bank where they had a registered pension plan as part of their compensation. The client is transferred by the bank and now lives in Montreal. If the client stops working for the bank and transfer the eligible portion of the commuted value of their registered pension plan to a LIRA, what jurisdiction will apply to the LIRA? What jurisdiction applies? Well, the federal rules would apply. It would therefore be transferred to a locked-in RRSP because the registered pension plan of origin had been offered by a bank and was therefore subject to federal jurisdiction, not Ontario jurisdiction. For employers whose pension plans are subject to federal legislation, think of the province of residence for the client where they work simply as being Canada. It doesn't matter what province the client worked in for all those years at the bank. In this particular scenario, we have a client who lived and worked in Bathurst, New Brunswick, and worked for Caisse Populaire, whose head office is in Quebec. The company's pension plan was naturally registered in Quebec. The client had participated in the pension plan for many years. She leaves her long-time job and transfers the eligible commuted value to a LIRA using a local advisor in Bathurst. What jurisdiction will apply to a LIRA? What do you think? Well, it's the rules for New Brunswick that would apply. In this case, New Brunswick Pension Benefits Act, since the Caisse Populaire's activities are governed under provincial jurisdiction. It doesn't matter that the client lived in New Brunswick, it's where she worked and what jurisdiction applied to her former employer's pension plan, not the fact that the company's pension plan was registered in Quebec. Here's scenario 4. We have a client here who lived in Ottawa and worked for a retailer in Hull, Quebec. The company has a national charter. Its head office is in Toronto. The client had a registered pension plan as part of her compensation package. She lost her job due to restructuring. She decides to commute her pension plan and move it to a LIRA with an advisor in Ottawa. That's where she lived. What jurisdiction will apply to the LIRA? So what do you think? Since the retailer's activities are under provincial jurisdiction and that the client reported for work at an establishment in Quebec, the benefits under the plan are subject to Quebec law, specifically the Supplemental Pension Benefits Act. Finally, we have a client who lived in Montreal where she worked for an airline company. She had a registered pension plan as part of her compensation package. The client still lives in Montreal, but has stopped working for that airline company and decided to transfer the eligible portion of the accumulated value of a registered pension plan to a LIRA. What jurisdiction will apply to the LIRA? Well, the federal rules would apply and not the Quebec provincial rules. Therefore, the registered plan would have to be transferred to a locked-in RRSP. As you can see, advisors need to be aware of these rules in order to give proper advice about what a client may or may not be able to do with their locked-in plan. Here's another important point. Generally speaking, an owner of a locked-in retirement account cannot combine the money in it with another LIRA or locked-in account governed by the pension laws of another jurisdiction. They need to be kept separately. So now let's consider special withdrawals. As previously mentioned, the details allowing for special withdrawals vary depending on the applicable legislation. However, there are commonalities between the different jurisdictions. Indeed, even though the specific applicable amounts, periods, or ages may vary, the general circumstances under which a special withdrawal is allowed tend to show some similarities. Some of these general circumstances include an early payout for shortened life expectancy, unlocking due to financial hardship. Think of what's happening with COVID-19, the unlocking of small plan balances, or unlocking due to non-residency. A special withdrawal is also possible when unlocking funds and transferring monies to an RSP or a RIF. When you're looking at transferring the excess between the minimum and maximum annual withdrawal amount. Withdrawals in excess over the minimum lift up to the maximum annual limit can actually be withdrawn or transferred. And you can unlock a LIRA or a locked-in RSP due to the death of an annuitant and transfer that money to a spouse. If a person meets certain criteria to unlock their locked-in plan, the withdrawn amount will be fully taxable. But to avoid this taxable event of it, it may be possible in circumstances to transfer the unlocked amount on a tax-deferred basis to the annuitant's non-locked-in RSP or RIF. Let's look at these special withdrawals in further details. The first situation where it could be possible is when the participant's life expectancy is shortened. In most jurisdictions, a shortened life expectancy means that the participant has a life expectancy that has been shortened to less than 2 years because of a disability or an illness. In these situations, a withdrawal from a locked-in retirement account is possible in plans of all jurisdictions, federal and, of course, all provinces. In these circumstances, it's also possible to do a withdrawal from a life income fund, which is under federal legislation. Also, the legislation of all provinces, except the province of Quebec, allow for withdrawals from life income funds when the participant's life has been shortened because of a disability or an illness. In situations where a client who owns a LIF, which is regulated under the Quebec provincial laws, sees their life expectancy shortened because of a disability or an illness, advisors could recommend the following. So think of this as a planning opportunity. The LIF could be transferred to a LIRA on a tax-deferred basis. Once the transfer is completed, the client could request a withdrawal from the sum that has been transferred in the LIRA. The transfer, though, has to be done no later than December 31st of the year in which the holder reaches age 71. So there is a time limit here. Among the formalities that are necessary to complete such a withdrawal, the owner will have to provide certification from a physician that the disability or illness has considerably shortened their life. Now let's consider the unlocking due to financial hardship. Under the legislation of certain jurisdictions, it's possible to withdraw amounts when the plan owner is in a situation of financial hardship. In federal plans, a client with low income or a client who expects high medical or disability-related expenditures can unlock up to 50% of the year's maximum pensionable earnings, YMPE. So you're going to hear me say YMPE. It's a mouthful to say year's maximum pensionable earnings in a presentation like this. The YMPE is determined by the federal government and has been established for the civil or tax year of 2020 at $58,700. For federal plans, a client will be considered with low income if his or her income is less than 75% of the YMPE, or $44,025 for the year 2020. For plans under jurisdictions of Alberta, British Columbia, Ontario, and Nova Scotia, funds may also be withdrawn if the client is experiencing financial hardship. The details are slightly different between the provinces, but generally, a client will be considered to be experiencing financial hardship in any of the following situations. 1, the owner expects to have a low income in the upcoming 12 months. Each province has its own way of calculating what a low income is in that province. 2, foreclosure. There could be arrears of payment of a secured debt like a mortgage on a property that is the owner's principal residence. 3, there could be an eviction. The amount required to pay arrears in rent. Or 4, first month's rent and security deposit is required. The amount is required to pay first month's rent plus security deposit, and if that causes financial hardship, a withdrawal may be possible. And we're looking at medical costs. The total amount required to pay medical costs incurred and to be incurred in the year following the date in which the application is signed. So this is not retroactive. We're actually looking forward to what's going to be incurred in the year following the date on which the application is signed. When we're looking at the provinces of Saskatchewan, Manitoba, Quebec, New Brunswick, Newfoundland, Labrador, financial hardship does not allow the owner to withdraw locked-in funds. So not all provinces allow this access. So let's consider the unlocking of small plan balances. Unlocking small plan balances is possible in all jurisdictions except Prince Edward Island, where there is no act regulating registered pension plans. And even though this exception applies in almost all plans, it doesn't mean that the rules which allow unlocking small plan balances are the same in all jurisdictions. In fact, almost all jurisdictions have their own set of age and amount limitation. For federally regulated plans, the owner has to be 55 or older, and the total of all federal locked-in funds must not exceed 50% of the year's maximum pensionable earnings, or YMPE, which represent a total sum of $29,350 for 2020. These rules also apply to the plans of the territories of Nunavut, Northwest Territories, and Yukon. Now you may say, why do I care about that? And I said, well, your client may in fact be living in your province, but they ceased employment in those provinces. And now they've got that locked-in retirement account. For plans which are under the jurisdiction of Alberta or British Columbia, at all ages, it's possible to unlock the funds of an account if the value of that account is less than 20% of the year's maximum pensionable earnings, or YMPE, which represents an amount of $11,740 for 2020. For these two provinces, it's also possible to withdraw the funds from an account when the owner is age 65 or older if the sum of all locked-in plans is less than 40% of the YMPE, which represents an amount of $23,480 for the year 2020. So what about Manitoba? For plans under the jurisdiction of Manitoba, there is again a difference between situations where an owner is less than 65 years old and situations where he or she is 65 years of age or older. If the owner is 65 years of age or older, it will be possible to unlock the funds if the balance of all of the owner's liras and lifts are less than 40% of the YMPE for the year in which the owner applied for the withdrawal. If the owner is less than 65 years old, a withdrawal will be possible if the total of the balances of all of the owner's liras and lifts and the interest on those balances calculated and compounded annually at the rate of 6% per annum from December 31st of the year in which the application is filed to the end of the year in which the owner turns 65 is less than 40% of the YMPE for the year of application of withdrawal. So a complicated process, but that calculation will be done for you. Well, what happens in New Brunswick? For plans regulated by the laws of New Brunswick, the limits are the same as those in the province of Manitoba, except that it is only possible to unlock small balances from a lira in New Brunswick. That said, you must include the value of any and all lifts in the calculation of small balances, whose total may qualify for unlocking based on a formula. So all locked-in account balances must be included, even though you can't make a withdrawal from the actual LIF. So when an owner is less than 65 years old, in situations where he is 65 years old, the calculation is a little bit different. If the owner is 65 years of age and older, it will be possible to unlock funds from a LIRA if the balances of all of the owner's LIRAs and LIFs is less than 40% of the YMPE for the year in which the owner applied for the withdrawal. If the owner is less than 65 years of age, a withdrawal from a LIRA will be possible if the total of the balances of all the owner's LIRAs and LIFs and the interest on those balances, calculated and compounded annually at the rate of 6% per annum from December 31st of the year in which the application is filed to the end of the year in which the owner turns 65, is less than 40% of the YMPE for the year of application of withdrawal. Well, if you're 64 years old, that could be years worth of interest. If you're 60 and you're allowed to do it, well, that could be 5 years worth of interest and earnings. So it's not necessarily the same thing depending what province you're in. For plans regulated by the laws of Newfoundland and Labrador at all ages, it's possible to unlock funds if the balance of all of the owner's LIRAs, LIFs, and LIFs is less than 10% of the YMPE for the year in which the owner applied for withdrawal. Also, at the earliest of age 55 and the date at which the owner is entitled to receive the pension benefit, a withdrawal will be possible if the total of the balances of all of the owner's LIRAs, LRIFs, and LIFs is less than 40% of the YMPE, the year's maximum pensionable earnings for the year of application or withdrawal. For plans regulated by the laws of Nova Scotia, funds can be unlocked if the owner is at least age 65 and the value of all of his or her locked-in accounts is less than 40% of the YMPE, which is $23,480 in 2020. In Ontario, funds can be unlocked if the owner is at least 85 and the value of all of his or her Ontario locked-in accounts, it again is less than 40% of YMPE, the same figure, $23,480 for 2020. Let's look at Quebec. For Quebec legislated regulated plans, the entire amount of a LIRA or LIF can be withdrawn, provided that the total amount accumulated in certain retirement savings instruments is less than 40% of the YMPE. Now, these retirement savings instruments include LIRAs, LIFs, simplified pension plans or SIPs, locked-in RRSPs, voluntary retirement savings plans. You might see the initialism VRSP, defined contribution pension plans, defined contribution component of a defined benefit pension plan. So the catch-all to arrive at that amount is much more inclusive, and that total has to be below 40% of the YMPE. Again, it's the total of the locked-in amounts in those retirement savings instruments, which has to be less than 40% of the YMPE for the owner to be able to unlock the funds. What happens in Saskatchewan? Well, for plans regulated by the laws of Saskatchewan, funds can be unlocked if the owner is at least age 65 and the value of all his or her locked-in accounts is less than 40% of the YMPE. So you see some similarities here, $22,480 in the year 2020. Let's consider unlocking due to non-residency. They've had enough, and despite of all the turmoil occurring in the United States, they're going to make Florida their permanent location. They're going to make Arizona the place where they're going to call home for the rest of their lives. The term resident is not defined in the Income Tax Act. However, its meaning has been considered by the courts of Canada, including the Thompson decision rendered by the Supreme Court of Canada. That was way back in 1946. In that decision, the court held that one is ordinarily resident in the place where, in the settled routine of his life, he regularly, normally, or customarily lives. An individual who is ordinarily resident in Canada is considered to be factually resident in Canada, but the individual may still be deemed to be resident in Canada for tax purposes. Advisors who have clients with residences in Canada and in another country or countries should be particularly aware of the residency rules, so independent counsel should be sought if necessary. For federally regulated plans, as well as for plans under the jurisdictions of British Columbia, Manitoba, Ontario, and Quebec, at any age, if a client has been non-resident of Canada for at least 2 years, he or she can withdraw the balance of his or her LIRA or LIF all at once. In New Brunswick, the stipulation is that the owner and his or her spouse or common law partner, if any, are not resident in Canada for the purposes of the Income Tax Act. So again, BC, federal, Manitoba, Ontario, Quebec, any age, but non-resident for at least 2 years, New Brunswick, you're looking at a situation where the owner and the spouse or common law partner have to be non-residents in Canada for the purposes of the Income Tax Act. If we're looking at Alberta as an example, there is no non-residency period. A plan owner can unlock the money in his or LIRA or LIF under the non-residency rule with no minimum non-residency period if the Canada Revenue Agency has declared the owner a non-resident for income tax purposes. In the provinces of Saskatchewan, Nova Scotia, Newfoundland, and Labrador, the status of a non-resident of an individual is not a reason that allows for the unlocking of funds. So non-residency is not necessarily a green card that gets you out of the country and allows you to unlock all of your funds. Let's look at transferring monies to an RSP or a RIF. Some jurisdictions allow for the unlocking of locked-in plans by permitting the owner to transfer part of the value of the locked-in plan to an RSP or a RIF. It's still registered, and even though the money remains in a registered account, advisors should be aware that these unlocking rules, as it allows for increased flexibility for their clients, and even then we're looking at different types of strategies. The jurisdictions of British Columbia, Nova Scotia, New Brunswick, Newfoundland, and Labrador do not allow unlocking of locked-in funds, but a transfer of the funds to the holder's RSP or RIF account. But let's look at the jurisdictions where such unlocking is possible, and if so, upon which conditions. For federal plans, if a person will be 55 years of age or older within the calendar year and exercises the option within 60 days of that point in time, then the funds are initially deposited in the Restricted Life Income Fund or an RLIF. The person may transfer 50% of the funds in that RLIF to an RSP or a RIF. Cash can then be withdrawn from either of these vehicles, subject to any applicable income tax rules. The funds cannot be taken directly in cash from the RLIF. For Alberta plans, an owner of a LIRA is eligible to make an unlocking election if that person has at least attained the age of 50. A non-unlocking election can only be made once. It may only be made not more than 90 days before they were transferred to a retirement income account from either a pension plan or from a locked-in retirement account. An unlocking of up to 50% of the balance in a locked-in retirement account may not be made after the pension commencement date of the owner of the locked-in retirement account. The amount unlocked may be transferred to an RSP if and to the extent that the Income Tax Act allows. Each year, the holder of a LIF, which is regulated under the laws of Quebec, can transfer a specific amount from the LIF to an RSP or a RIF. The amount must meet the following requirements. 1, it must not include the minimum amount that must be withdrawn from the LIF, since that amount must be taken as cash payment. It must not be calculated according to the RSP deduction limit, and it must not increase the yearly maximum that can be withdrawn from the LIF. Ontario's pension laws allow owners of a LIF to transfer up to 50% of the money transferred into a LIF from a pension plan or a locked-in retirement account, LIRA, which may be transferred in turn to an unlocked registered retirement savings plan or a registered retirement income fund. Now, this can only be done within 60 days from the date the money was transferred into the LIF from a pension plan or a LIRA. The law does not prohibit you to transfer that money to a spousal RSP or spousal RIF. However, there may be restrictions under the Federal Income Tax Act for such a transfer. In Saskatchewan, on attaining age 55 or older and with spousal consent, an individual may transfer to a prescribed RIF from a LIRA or from a pension plan if the pension plan permits such a transfer. For plans under the jurisdiction of Manitoba, a person must be at least 55 years of age to apply. The owner of the LIF may apply for a one-time transfer of up to 50% of his locked-in money from his or her LIF to a prescribed RIF. And simply as a reminder, a prescribed RIF is the same as a RIF, except that it is also subject to certain rules set out in Manitoba's Act and regulations. Funds in a prescribed RIF are not locked in, and spousal or common law partner consent is required. Let's consider unlocking due to death of the annuitant and a transfer to a spouse. When a LIRA or a LIF owner dies, the balance is paid to his or her spouse, or if there is no spouse or the spouse has renounced it, to the heirs. In the provinces of Ontario, Quebec, Nova Scotia, New Brunswick, Newfoundland, Labrador, following the death of the annuitant and the transfer to the spouse or common law partner, the sums transferred from the LIRA or the locked-in RSP are unlocked. This is true whether the sums are transferred on a tax-deferred basis to the spouse or common law partner or not. In Saskatchewan, the surviving spouse has certain transfer options, among which is taking a lump sum payment, thereby unlocking the sums that were in the LIRA. The situation is different for federally regulated plans as well as for plans under the jurisdictions of Alberta, British Columbia, and Manitoba, where the sums will remain locked in after the death of the annuitant and the transfer to the spouse or common law partner. And remember, it's not where the client is living, it's where the client was working when they were part of that particular pension plan. For LIFs in the jurisdictions of Alberta, Manitoba, Ontario, Quebec, Nova Scotia, New Brunswick, Newfoundland, Labrador, following the death of the annuitant and the transfer to the spouse or common law partner, the sums transferred from the owner's LIF will be unlocked. This is also true for LRIFs held by clients in the province of Newfoundland and Labrador. Finally, in Saskatchewan, on the death of the PRIF contract owner, the spouse has certain transfer options, among which is taking a lump sum payment, thereby unlocking the sums that were part of that PRIF. However, for plans under jurisdictions of the federal or British Columbia legislation, the sums will remain locked in after the death of the annuitant and the transfer of the spouse or common law partner. Now, I've written an article here. This is actually an update of an article that I first wrote probably about 12 years ago. It's been updated a number of times. It's now been most recently updated this past summer. That contains all these rules for the various jurisdictions. So I encourage you to go through that. We've gone through a lot of numbers, a lot of details and conditions. So again, go to that site. They're available to all participants. It's available on the advisor website under business building and the step up newsletters. It's a good tool to use as a refresher of the rules that we've just seen together, or as a reference when your clients will have questions regarding unlocking their locked-in pension accounts. Reach out to your account executive team for a copy if you can't find it yourself. So what are some planning opportunities? Because I talked about the fact we'd have some planning opportunities here. At this point, I think you'll agree that when we say that the area of locked-in accounts is very complex and technical, it is. Also, considering how limited the situations to withdraw amounts from a locked-in RSP and LIRAs are, it's easy to understand why these plans are called locked in. Therefore, when possible, advisors should generally be looking for opportunities to transfer funds from locked-in accounts to non-locked-in accounts on a tax-deferred basis. Such transfers provides the client and the advisor with more flexibility regarding the use of the funds held in the account. One possibility that can be used is based on the notion that for tax purposes, LIFs are considered RIFs. Since the Income Tax Act makes it possible to transfer amounts from a RIF to a RIF on a tax-deferred basis, it would be possible to transfer amounts not only from one LIF to another, but also from a LIF to a regular unlocked RIF on a tax-deferred basis within limitations. Such a transfer ends the locked-in characteristics of a LIF, and that in turn provides more flexibility on the withdrawal of sums from the locked-in plan. It also presents more estate planning options and who may be entitled to funds in the plan holder's passing. This increased flexibility makes it easier to adjust to varying cash flow needs during retirement, and as we'll see later, adds options to the products that could be purchased by the client. It is this possibility to do transfers on a tax-deferred basis that creates a couple of planning opportunities. Therefore, the first step should be for advisors to establish with their clients how much these clients will need from their LIF to live. What are their expenses? And once that amount is determined, if it is less than the maximum, the client could be advised to transfer the difference between the determined amount and the maximum amount permitted under the pension legislation to a RIF on a tax-deferred basis. The client's marginal tax rate will be applied to the minimum required payment that he or she receives. After the transfer, the transferred amount is still subject to the same minimum withdrawal amount, but now there's no maximum for the sums that have been transferred. Since the transferred amount is not a locked-in vehicle, the client benefits from more flexibility on this transferred amount for both withdrawals and who they can name as a beneficiary. So let's look at what it could take and what you could do like in a scenario or two. Keep in mind the following. The COVID-19 pandemic generated a dramatic drop in investment market values and added extra volatility to performance. This particularly impacts near retirees and retirees. These investors saw their portfolios drop in value either during the retirement risk zone, the 5 to 10 years flanking the retirement date, or when they are forced to withdraw a minimum amount from the registered retirement income fund, whether they need it or not. They're also depending on a certain level of income down the road, which is dropping because the assets generating that income have dropped in value. In response to that, the federal government lowered the annual minimum withdrawal amount for RIFs and LIFs by 25% in March for 2020 tax year. If your client hasn't made their full registered retirement income fund, RIF, or life income fund LIF withdrawal yet this year, could they benefit from the measure? Well, this move gives a number of investors recovery time for their portfolios if they are both able and desirous of deferring withdrawals in favor of potential tax-deferred growth. They simply can take out a smaller amount. That leads to another opportunity for life income holders. Because the lower minimum in LIFs means a larger amount may be moved to an unlocked registered retirement plan on a tax-deferred basis. And that in turn provides more flexibility to access cash down the road without regulatory limits. Let's look at what happens with Diane. Diane is 66 years old. She used to live in Gatineau. She has worked all her life as an employee of the Canadian government. Part of her compensation as an employee of the government included a registered pension plan. Diane is now retired, and the sums that she had in her registered pension plan are now in a LIF. The fair market value of that property held in connection with the LIF at the beginning of the year was $500,000. For her retirement, she decided to live in Victoria, where she now lives to enjoy the mild weather. As we have seen, the federal legislation will apply to the LIF, even though Diane lived and worked in the province of Quebec, and she now lives in British Columbia. Considering that Diane was 66 at the beginning of the year and that the fair market value of the property held in connection with the funds at the beginning of the year was $500,000, the minimum amount that Diane has to withdraw from her LIF is $20,850. That's the formula. While the maximum amount that she could withdraw is $26,050. So there's your minimum and maximum. Diane tells her advisor that considering her other sources of income, she doesn't need more than the minimum of $20,850 to live comfortably. What should your advisor recommend? Well, Diane's advisor could recommend that the amount of $5,200, which is the difference between the minimum and the maximum, be transferred on a tax-deferred basis to a RIF owned by Diane. This sum now benefits from more flexibility and could be accessed easily if a bigger expenditure had to be made. Perhaps she had to adapt her house to a reduced mobility, for instance, somewhere down the road. This tax-deferred transfer could be repeated every year in the upcoming years until all the funds in LIF have been transferred. For more information on the minimum and maximum withdrawal percentages applicable to LIFs under the different jurisdictions, I encourage you to consult this document, which gives all the detailed, up-to-date information on the different applicable limits. It's available on the advisor website. You can also reach out to your account executive team for a copy. Now let's consider product mismatches. I want to discuss a situation where a good product can lead to a less than optimal situation for the client because of the positioning of the product. As we discussed in greater detail in our presentation, Guaranteed Lifetime Income, the 90% factor, Canadians want retirement income which is guaranteed to last their lifetime, that it's predictable and which keeps pace with inflation. These objectives are met by a guaranteed minimum withdrawal benefit plan, such as Empire Life's Class Plus 3.0, which pays out a contractual fixed amount and is therefore a product that should be considered as part of the client's overall retirement planning. However, here is an all too common product solution mismatch, which can be problematic for the client. If the client plus the plan that he has, the Class Plus 3.0, is purchased in a LIF, those payments may not hit maximums allowed under pension legislation. As a result, investors will lose the opportunity to maximize the movement of excess locked-in amounts to an unlocked registered plan without penalty, and then forego getting relief from legislated pension payments, being able to take out lump sums without demonstrating hardship, and we also have to deal with the issue of excess withdrawal treatment on a guaranteed minimum withdrawal benefits, which can also impact guarantees in that plan. Then there is the consideration of priority rights of a spouse on dealing with a policy and who may be entitled to net proceeds on the death of the plan holder. So let's look at what happened with Louis. Louis is 72 years old. He worked for a Canadian bank for 35 years. Part of his compensation package included a registered pension plan. He's now retired. He comes to see you for advice as he never had an advisor before. You analyze his list of assets. You notice that he owns a lift, which resulted from the transfer of the assets in his registered pension plan. With the $250,000 Louis held in his lift, he purchased Empire Life's Class Plus 3.0. He made that purchase after talking with some of his friends who had already purchased the same product and who found it met their retirement income plan objectives very well. Louis also had a tax-free savings account through which he owns $250,000 of GICs. And as we've seen, the province of residence of Louis does not determine the regulations of which jurisdiction will apply to his lift. Since the bank falls under federal jurisdiction, his pension plan is governed by federal jurisdiction. So what are the legal limits? Well, considering that Louis was 72 at the beginning of the year and that the fair market value of the property held in connection with the fund at the beginning of the year was $250,000, the minimum amount that Louis has to withdraw from the plan is $13,500, while the maximum that he could withdraw is $15,900. There's a gap there of about $2,400 a year. Louis' lifetime withdrawal amount, which is the amount that he could normally withdraw without negative consequences under his Class Plus 3.0, is $11,000. However, the Class Plus 3.0 is a contractual provision which allows the withdrawal amount to be at least the minimum legal amount. In this case, Louis would be allowed to withdraw the legally required minimum of $13,500 without any adverse effects. However, Louis will not be able to unlock the difference between the minimum and the maximum from the guaranteed withdrawal benefit plan and the maximum under a lift, like Diane was able to do earlier without penalty. So the opportunity to increase the flexibility of Louis' assets is lost for him. Now, if Louis had come to see you before he had purchased his Class Plus 3.0 and before he had attended the seminar, what could you have recommended? Because he still wants to buy that particular product. You could have recommended that he buy the Class Plus 3.0 with the amounts that are in his tax-free savings account instead of purchasing GICs. If he had done that, the lifetime withdrawal amount of $11,000 could have been withdrawn fully by Louis on a tax-exempt basis. Furthermore, since this source of cash flow doesn't affect the calculation of Louis' net income, it does not impact negatively his access to various old age benefits, which may decrease as the recipient's net income increases. And instead of putting his money into a guaranteed withdrawal benefit plan, you could have recommended a guaranteed investment fund for Louis' locked-in account. You then could have taken advantage of the transfer and unlocking strategy. For more information on what Canadians want as features of their retirement plans and how guaranteed lifetime income forms an important part of their objectives, we invite you to watch our two-part webinar on guaranteed lifetime income. This two-part series also reviews many client scenarios with different client profiles to assess how different products could meet the different objectives and backgrounds of these clients. We've covered off a lot today. And yes, I broke all my own rules by using initialisms way more than I wanted to do, but I want to make sure I can get this whole session in under an hour. So here are the main areas we covered. 1, the origins of locked-in retirement accounts, an important consideration for advisors working with clients who have been presented with the opportunity to commute their company pension plan and transfer the eligible amount to a locked-in account. 2, the distinctions between withdrawals and taxable withdrawals. 3, special withdrawals from locked-in plans, especially important considering the impact the pandemic has had on people's finances. There may be increased inquiries and demand to access locked-in funds in order to cover living expenses and special needs. 4, we've covered a planning opportunity to unlock some locked-in funds. And 5, while leaving the unlocked monies registered and now more easily accessible. And 6, the session also pointed out the mismatch of certain products, accounts, and retirement plan structures. Be sure to visit our online resources for more information in the companion pieces of the session. If you'd like a copy of today's presentation, please reach out to your account executive and we can send the handout version of the session to all of you. Finally, Empire Life is a company that you can trust. We've been helping Canadians meet their financial needs since 1923. We're rated among the top 10 life insurance companies in Canada. We've been rated A Excellent by the AM Best Company. We've been managing segregated funds for over 50 years. We are committed to guaranteed withdrawal benefits, and we've been doing that since 2008. And we offer diversified investment choices ranging from fixed income up to 100% equity, including our tactically managed emblem gift portfolios. Thank you for having been with us today.